Thank you, Anna. Hi, everyone. I'm Hanovi Schoonover, the Training and Resource Coordinator at Redwind Consulting, and I want to welcome you to the webinar. Today, we'll be covering legal considerations when providing advocacy to children and youth. Joining us today is Sandy Davidson. Sandy is part of the Anishinaabe and White Earth Nation. She has resisted oppression over a lifetime and considered herself a product of colonization and forced assimilation. She has survived the era of the indentured servant, foster care, and adoption into a non-native family. She has worked as an advocate for 27 years when she coordinated the children's program in a rural shelter surrounded by 3 reservations, worked as a child advocate in a large urban shelter, coordinated the children's program at the Minnesota Coalition for Battered Women, and for the past 15 years has worked at Praxis International, a national technical assistant provider for the Office of Violence Against Women. And I will now turn it over to her. Oh, I believe Sandy is having some slight microphone issues.
Hello, can you hear me?
Yeah, we can hear you.
Oh, I am so sorry. Hello, everybody. So we're off to a great start. I was trying to unmute and I disconnected, so apologies for that. But I'm very happy to be on this webinar, and I hope it goes more smoothly from here on in. How is everybody? I like to keep these a little bit informal, so if you have questions, please ask them in the chat box, and I will try to respond to things as things come up. But before we get started, I just wanted to make a couple comments. I find these webinars kind of challenging. Number one, I don't get to see your faces, and I'm not sure, if you're bored to tears or, if you're totally fascinating. For sure, I'm not sure what everybody is interested in. I also know there's a lot of diversity in the programming and tribal affiliations, and whether or not, for example, you're a PL 280 state, if you have your own tribal infrastructure, such as the tribal or BIA law enforcement, et cetera. So those are always, challenges, when you're doing something like this, because I can't meet the needs of everybody. But I will provide a broad overview with the understanding that most of you will have to do some research within your own tribal communities around these legal issues. And finally, I just want to say that I come from an advocacy perspective where our goal as advocates is to, to paraphrase the words of Archbishop Desmond Tutu, because it so accurately reflects what we do as advocates in our quest for justice. Desmond Tutu said that we must tell our truths, And this is so critical as we work from our tribal perspectives to, to speak our truths, to let funders and other community members and society as a whole understand, where we're coming from. Another thing he said is, to the extent possible, repair the harm. And for most of us working in advocacy programs, this is what we try to do, is repair the harm on so many different levels. And finally, the goal is, as we work for justice, is to eradicate the conditions that cause harm in the first place. In other words, as we do our work as advocates, our goal is to really put ourselves out of work, right? I'm sure you've all heard that many times. So, as advocates, we work with individual children. We provide systems advocacy, in this case, legal advocacy. And we do this for individual children and the non-offending parent. And we do our research and work to change those conditions that result in children and youth and their families, so they no longer have to experience physical or sexual assault, oppression in any form, and especially racism. So in terms of legal advocacy, we work to change how systems respond. And, there's any number of systems that interact with children and their families around legal issues. But as we move forward, I'm going to cover just a couple of primary interveners. So this first slide here is just kind of giving an overview of what advocates need to know. You need to know, of course, your tribal codes. What does your tribe say you folks as advocates should do to respond to those that are experiencing physical or sexual violence? And it's also important, and I think this is across the board, whether you're a PL 280 state or not, that you should know the state and federal laws, because so many of them impact us in tribal communities, even if we have our own infrastructure. So it's important to know what the intervening systems are and their role. And like I said, I'll probably be just covering two of the main interveners, but there's any number of agencies that intervene. It might be guardians ad litem, child advocacy centers, schools for sure, not just child protection and law enforcement. But advocates really need to know what your mandated reporting laws are and what rights adolescents have. For those who have been sexually abused, those that are in abusive relationships, two-spirit or LGBTQ, lesbian, gay, bisexual, transgender or queer youth. What are the school policies in your communities, regarding racism or responses to bullying? Or if an adolescent has a restraining order. We hear this many, many times where a youth is involved in a teen, they call it teen dating relationship or whatever. But, what are your school policies around those issues? So I'm going to talk just briefly about the role of two of the primary interveners when youth and children are involved. And one of them, of course, is Child Protective Services, whether it's tribal or county, and law enforcement, whether it's tribal, BIA, county, whatever. And just talk briefly about the purpose of each one. Like Child Protective Services, their primary purpose, and this is said in different ways in different states or communities or tribal communities, but every agency has like a purpose or a mission statement or whatever, but primarily their goal is to protect children and adolescents and keep them safe in the home. The state, federal, and tribal laws direct their work. This is what guides how they do their work on a day-to-day basis. A primary role is to screen and investigate child abuse and neglect. And there's a whole process that's been put in place from the first 911 call or entry into the child protective system. And but their role is to screen cases in or screen them out, and then to determine if an investigation needs to take place. And then there's a whole bunch of processes that take place after that initial screening, and if they decide that they have enough information to investigate. They're linked to many different community agencies, primarily law enforcement, to the courts, of course, to the Indian Child Welfare, and to the vendors that help establish case plans for cases that are open within that system. Now, law enforcement, like I said, can be tribal, BIA, county. It's hard to, I'm giving this broad stroke, so, I hope it makes sense to you all, but the primary purpose of law enforcement is to enforce the law, right? And it's about public safety. There are state, federal, and tribal laws that direct their work. Again, these laws kind of tell them what they can and can't do within their particular field of work. A primary function is to investigate and to move towards prosecution. So if there is, for example, a sexual assault or a domestic violence situation, whatever it is, they gather that information, document it, and prepare to move a case forward to prosecute. They are linked to other agencies as well, including advocacy programs, but primarily to prosecution, probation, medical facilities, etc. So let's start talking about sexual assault and what advocates need to know. Now, this is where it gets tricky for me as a presenter because I don't know, number one, what you all know or what is available in your community. But basically, some of the overarching things that every advocate should know are what are the rights, what rights do adolescent victims have in your local community? For example, is the victim's sexual history admissible as evidence? Typically, no, but there are some jurisdictions, where they allow that testimony in or it influences their decision. But, sometimes the judge specifically allows it. But those are things that you need to know as an advocate when you are advocating for children and youth in your community. The other thing is, do tribal codes or state statutes recognize both male and female victims? Sometimes they're just recognizing female victims, but we know that there are male victims, but we also know that there's a distinction between battering and the power dynamics used in a battering situation, which leads to most victims being perpetrated on by men. But you need to know that what your tribal codes or your state statutes recognize. Also, do they recognize Two-Spirit or LGBTQ youth? What's in place to hold offenders accountable? Now, I use this term, offenders accountable, but a lot of times it has like the connotation that there is some kind of legal response or they're held accountable through the criminal legal system or whatever. But I also like to think about what's in place in your community, especially where that you work or your community works to have the harm doers take responsibility for their actions. Many times law enforcement, whether it's state or BIA or tribal or whatever, they step in and they go through the criminal legal system, whatever that is in place. But we also know that we have community steps that we can take where we might use a cultural approach, to help harm doers realize and realize the harm they've caused and to take responsibility. But do you know what's in place in your community? And if you don't, that's something I always encourage advocates to check out because there's so much diversity and so many things happening in different communities. I just like to put this in here and get everybody thinking about it, right? Another thing that we should know is our children specifically protected from abuse by persons in a position of authority. And in tribal communities, does that include spiritual leaders? Now, I think this is an area that, you know, in more recent years, we're hearing more and more about spiritual leaders, medicine men, people in those positions of power, certainly clergy, counselors or therapists that are taking advantage of and sexually or physically abusing those that are, you know, coming to them for help. So what's in place in your community, I guess, is just the question that I'm putting out there, and encouraging you to do a little bit more investigating, you know, if that's something you're not too sure about. Is corroboration of the victim's testimony required? It should not be. You know, they should have information through the investigations or whatever in place and sufficient enough to go through with a prosecution without having to prove what the victim's testimony is. But that's always a challenge for communities, for advocates, I should say. Is a focus on if a victim resisted or not. Now, it should not be, but again, so many interveners, you know, regardless of what policies or practices are in place, there's those individuals who believe that a victim should resist and resist, you know, with force, you know, to kind of prove that it was actually an assault. But we know as advocates that this just isn't the case. Many times a victim will freeze up, or, you know, there's so much fear, and we know all the emotions that are involved, but, you know, unfortunately some of the interveners don't always recognize that. But as an advocate, those are certainly things that you should know. Here's another thing to think about in terms of what an advocate should know. Who pays? If someone is sexually assaulted, who pays for the exam? Now, in January 2009, there was a federal law which would impact tribal communities as well, but it was enacted as part of the Violence Against Women Act. And it requires states to make sure that sexual assault victims can receive forensic medical exams free of charge. And what I've heard from advocates across the country, sometimes they're not aware of that, or they're not sure how to advocate for someone to make sure that the exam is done for free. Of course, there's other considerations. Sometimes, you know, a victim does not want to go through with an exam, you know, but as an advocate, your role, of course, is to give them the information so they can make an informed decision, right? You know, whether they want to make a police report or not, you know, but once they have the information, they can at least make that decision to move forward, and they should know that they do not have to pay for the exam. Now, the other thing to consider is maybe you have Indian Health Service, or you don't have someone that can do an exam in your local community. Where do you take that victim to get an exam if that should happen? And if it is off the reservation or off tribal lands, you know, is that facility, do they know and understand that victims do not have to pay for those exams? So we're still talking about sexual assault here. So how do your tribal codes or state statutes define criminal sexual conduct? Now, this is something, you know, as a new advocate, and I didn't know what the tribal codes were or what the state statutes were. I don't know what your level of experience is, you folks calling in. Some of you may have tons of experience. Some of you may be relatively new. But this is important to understand what the legal definition is of criminal sexual conduct as you move forward to provide legal advocacy for a victim. Well, let me back up just a little bit here when we're talking about those the definitions of criminal sexual conduct, because that might vary from state to state or tribal community to tribal community. But let me just give you just like a broad overview, because I think most states or codes have like a definition of what first-degree criminal sexual assault is, which would be a felony and includes sexual penetration and one of several other conditions such as use of weapons, if the perpetrator is in a position of authority, the age of the perpetrator and the age of the victim, and how much physical injury was done. So that would be first degree. Second degree is also a felony, and it's the same as the first degree, but there's no penetration. Third degree is also a felony, penetration and one of several other conditions such as force used without inflicting injury. And I like to think of that force doesn't just include physical force, it includes instilling fear, threatening family members. Those are all ways that people are forced to keep the secret of the perpetrator. And this one also includes the age of the perpetrator and the age of the victim. Fourth degree is, the same as the third degree, but with no penetration. And then fifth degree is non-felony. All the others, throughout the country, from what I've heard, it may vary, I don't know for sure. But fifth degree is usually typically non-felony charge, non-consensual and sexual contact of intimate parts. So that's kind of the legal definition, and like I said, it might vary from state to state, from community to community. And again, I encourage you as an advocate to, if you don't know what the definition is, talk with someone that can help you understand, or, I'm an aging advocate, so I don't use the internet as often as I should because I don't think about it. But for some of you younger folks, that have access to the internet, I mean, you can go right on there and get that information in a heartbeat. So that's pretty exciting. I wish I would have had that tool, when I was a young advocate or an early new advocate. The legal definitions, usually sexual assault and sexual violence, are used interchangeably. Both terms are used to describe a wide variety of abuses. And, I could probably list 10 off the top of my head as can you, it includes not just rape, but it could include sexual harassment or child abuse, any number of elder abuse, when elders are raped, and unfortunately I hear more and more stories about elders being raped. It's horrible, the stories I've been hearing. But, the term rape is most often used to describe forced penetration, but forced touch is also a serious crime. And then I've just listed, the felony includes penetration in the first to fourth degree, and a gross misdemeanor is usually contact or the fifth degree. So let's talk a little bit about your role as a mandated reporter. And, what it means to report the maltreatment of minors. What are your local requirements? That's something that, each and every one of you should know, are you a mandated reporter, and what steps do you need to take within your program if you are required to submit a report. Most states, and tribes must report if they suspect that a child is being neglected or abused. It's not your role as an advocate to prove that or whatever, but if you suspect or if information has been disclosed to you and as a mandated reporter, you must make that report. And a lot of places require that if a child has been neglected or abused within the past 3 years, you need to make a report to Child Protection. It's important to call if a child is in immediate danger, and if that happens, call 911, because that's, again, the role of law enforcement is to respond. And, they, in turn, once they get the call, and if they, investigate or, go to the scene, they're going to determine if Child Protection should be called or, how the situation should be handled. A verbal report. Now, most places say that if you have to make a verbal report immediately. Typically, no longer than 24 hours, which just means you pick up the phone, call, Child Protection, whether it's state or tribal or whoever it is, and say, hey, I suspect this child is in danger, and you give them the information. That information includes, a very descriptive, I'm losing my words here. They want you to describe very clearly what happened. If you do a written report, you can get more, usually they want more detail in terms of what you know about how that child was neglected or abused. And typically a written report needs to be submitted within 72 hours, and usually weekends and holidays are excluded. And again, this is just something, know what's needed in your particular community. Excuse me. So minor consent to medical treatment. Now, as a mandated reporter, it depends on what your state, federal, and tribal laws around sexual assault exams or of a minor. It might require the consent of a guardian or a parent. It just, like I said, it just depends on what's in statute or law in your community. Some jurisdictions recognize situations where parental consent may not be required. And as an advocate, you should know that. And like I said, if you can talk to your executive director or other staff people, or sometimes I used to reach out to other advocacy programs, that worked in my area to find out some of these things too. So there's different ways of finding out what's expected of you in your local community. If it's really an emergency or a child is really endangered, parental consent may not be required. If it's an emergency situation, or if you or another practitioner suspects child abuse, and especially severe beatings or sexual assault, not necessarily neglect. That's kind of in a different category. But when it's really extreme, the child or youth may not need parental consent. So some of the laws and forms guide the work, right? We've talked a little bit about the laws. I haven't said too much about the forms that guide the work. But as an advocate, you may or may not have confidentiality policies. Most likely you do because you are probably funded through the Violence Against Women Act, or you have federal, state, or tribal laws around confidentiality. A lot of states are now requiring 40 hours of training to be a sexual assault advocate. And within that training, you get a lot of information about, what law enforcement does, what child protection does, what some of these other interveners do to respond to children and youth, that are harmed. You also have program mission and policies that focus on women and survivors, but certainly on what to do if a child or youth if you suspect child abuse or neglect. Other systems have HIPAA in place, and that's just protects the medical records of those seeking help. Different systems have different tools. For example, child protection has the tool that I'm most familiar with is this structured decision-making tool, which is what they use to screen and identify if a child is abused or neglected. But again, what do you have in your community? What's in place? Does your local tribal child protection or state child protection, what do they use to assess for abuse and neglect? Other laws are come down from post boards or from licensing boards. And, what I thought about just now when I said that is, back in the day when I was doing more individual advocacy or working in programs, I couldn't figure out why guardians ad litem, which most of us know is sometimes are called CASAs, depending where you're from, but I couldn't figure out why guardians ad litem just seem never to work with me to protect the children. But I learned how their work was guided through the legislature. The legislature said, this is what you need to do as a guardian ad litem. This is how many hours of training you need. And this is the step-by-step process that you use as a guardian ad litem. Well, I come to find out that in our state, the guardians ad litem had like 6 to 8 hours of training on domestic and sexual assault, which was appalling to me. And I realized, that their jobs are very, very difficult. They have to make major decisions about a child's life, a family's life. But the point I'm trying to make is those are the laws that guided their work, and they didn't have a whole lot of understanding about the dynamics of physical and sexual assault. So, I realize that it's, as advocates, we wear many hats, and we get very, very busy in our programs. So it's hard to really do the homework to find out, what laws are in place and what forms different systems use. But the more you know, the better off or the better advocate you can be for those children or youth that are coming into your program. So I just want to pause here now and just see if anybody's chatted anything in, or just to take a moment to encourage you that if you do have a question or a comment, or if there's something you don't understand, please put it in the chat box and I'll try to respond to it. I hope to leave some time at the end for more questions, but I just want to take a moment to say that now. So there's a number of confidentiality safeguards for youth and children, primarily youth. Because we hear of a lot of youth, teenagers that, have been assaulted or physically or sexually or been victimized by racism or bullying and brought into different systems in different ways. But You know, the important to remember is that we like to give youth, you know, information so they can have informed consent, but it must be adhered to by law. It provides safety and safe environment for survivors, but it also protects first responders as well. Now, HIPAA is in place because it'll protect survivors' medical information. You know, and in part, you know, I mean, there's a lot of different reasons, but really, you know, for cultural considerations, for shame, it's a shame-based crime, for the shame and fear that survivors of sexual assault or sexual violence experience. You know, it's put in place to protect those survivors. And the medical information, you know, they don't want that medical information going out anywhere. And it allows only the START or the sexual assault response team and the patient to access information. And the survivor has the right to deny access. Indian Health Service, oh, I see this is a typo. The word correction thing always changes it to HIS, but it's supposed to be IHS. You all know that. But Indian Health Services, Privacy Act System of Records, and this is something, again, you can look online to get more information about it, but it's that it's a law that tribes implemented in tangent with HIPAA. And it protects medical, health, and billing records that contain medical or public health, nursing, mental health, and social service records. And they must be handled according to the Privacy Act. And again, this is something that, you know, when I first started doing advocacy, I didn't know a lot about, and I probably could have been a whole lot better advocate if I would have known some of these things back in the day. So I'd like to bring these up so you folks can really think about, you know, how to strengthen how you do advocacy.
Really quick, let's open it up to questions.
Sure.
So does anyone have any questions? As a reminder, you can type in the chat box or click the arm icon in the top left or top middle, and that will show that you have a question or comment.
Thank you, Hanavi. We'll just keep moving forward, and hopefully, you know, like I said, I don't know, I don't believe there's any dumb questions, so just don't be bashful, you know. If you got a question, ask it, you know. I may or may not be able to answer it too, but I don't really know what to respond to unless people ask questions. So, you know, I'd really encourage you, if something comes to mind or you don't, you know, want to know more about something, you know, just let me know. Let's move forward here and talk a little bit about informed consent. Again, this is important, you know, when you're working with youth. Well, I think when you work with children, you're working with the non-offending parent usually. But for sure, you know, if it's a younger victim, you want to work closely with the non-offending parent and to allow them to make informed consent about how to move forward with what has happened to their child. But for youth, it's a little bit different because sometimes parental consent is required, and other times, you know, the youth can make their own decision. And again, that's something I encourage you to look into in your own community. But typically, there are two consent processes. One is for medical evaluation and treatment. And the other one is for the forensic exam and evidence collection itself. You know, you want you want that youth, I'll speak more specifically to youth right now. You want that young person to understand, what they're signing, because they will have to sign to give consent, to have a medical evaluation and some kind of treatment. And, hopefully you want them to understand the full nature of what they are consenting to and to all the procedures. They need to know what the exam involves, who is going to do it, typically how it will, take place, the purpose of it. When a victim understands the purpose and they, if you're talking to them and you say, well, we can move forward and see if we can have the perpetrator arrested, or, we need this physical exam to take place to prove, that this person perpetrated violence against you, whatever it is, you want to explain it to them in a way that's not going to just horrify them, or it's going to be scary enough, but to present them the information in a factual way so they can make an informed decision about, what that evaluation will look like and what treatments might be used, what possible side effects. And, like I talked about, I think I talked about, like, the potential impact, in so many ways. But I just think it's so important for victims to know, because those forensic examinations are no fun, and the process of collecting evidence is no fun. So, for those of you that have taken a sexual assault advocacy training, and have probably have a lot of knowledge about what happens during a forensic exam. But, if you don't know, maybe you can talk to your local sexual assault nurse, or someone in your program or in your community that's really familiar, so so you too know what happens, so you can help explain this to a survivor so they know what to expect, so they can make an informed decision about consent. So, survivors need to know, what the consent is for. It's for the examination itself and the evidence collection. And a lot of times, and you probably know this, that, of course we're talking about sexual assault, right? That the examination itself is, it feels like a very invasive and humiliating experience, and then there's cultural considerations and any number of considerations. So, again, to, help the survivor understand what the exam is for and why the evidence is collected. Now, one of the things I've heard from advocates time and time again is survivors might just want a drink of water. They're so thirsty, they're hungry, they're exhausted, they're terrified, they're humiliated, all the emotions that go along with being a victim of a sexual assault. But in order to collect and maintain the integrity of the evidence, they don't let victims have a drink of water or eat food until that swab has been taken, or they've collected the evidence so it isn't contaminated. And I just like to add this too in terms of the role of advocacy and how you do legal advocacy, which I think also means working to change how a system responds. Like, I've talked to advocates that have sat with victims for hours in the waiting room or wherever, and they can't drink or they can't eat, and it's just so frustrating. So advocates have learned, that it's important to talk with hospital, whether it's IHS or local hospital, wherever it is, about their practices. What is taking so long? You have a survivor in crises. All they want is some basic comfort, like a drink of water or some food. Is there any way we can speed up the process? What can we as advocates do to help you, the hospital, nurse examiner, whoever it is, to speed up the process? Those, I'm just throwing that in as that's kind of the role of advocacy. It may not be legal advocacy as such, but it impacts the legal advocacy that you may need to do for a victim. They may need permission to take photographs, which includes colposcopic images. Now, don't ask me what that is. I'm assuming it's something internal, where they take pictures of inside of people. They put a little camera wherever. But again, to explain to a survivor, that this is something that needs to take place. They need consent to notify law enforcement or other authority. And it, again, depends on the reporting requirements in your community. You may certainly always consider using a release of information and get permission from the victim, from the survivor, to provide any kind of information to law enforcement or to any other system or person within your community. The consent might be to recontact patients for reasons related to their assault. That just means to follow up and get permission, to say yes or no. I have permission to contact you if we get test results back, to discuss how to move forward or whatever it is. But helping them understand. And also understanding and giving consent for toxicology screening. Now, these are all the tests that they have to do, again, to prepare for prosecution, which is why they have exams in the first place and evidence collection. Okay, I'm going to pause just a moment here. And again, if anybody has any questions or even comments, I'd be happy to watch for them. We're getting close to the end of our time here, so I just want to make sure any questions or comments are considered. Oh, it didn't move forward. Hold on here. Okay, let me pause here because Alicia has a comment. She said that she's glad that I mentioned the spiritual abuse, and that it's a topic that we don't talk about often enough. And you're wondering how we can have those conversations in our tribal communities, especially in such a critical time when many of our youth are reconnecting to our traditional ways. Oh, Alicia, this is a question that I think is so important. And, as an aging advocate, over the years I have heard and seen so many things. And, as Native people, our practices were outlawed for many, many years. And as an aging advocate, I remember back in the, 1978, when they passed the Indian Religious Freedom Act. Now this, I don't mean to sound disrespectful or flippant, but I remember the celebration in our community that we could finally, we had the right to practice our ceremonies, our traditions. And I saw so many people, it sounds terrible to say it this way, but, because I'm a little bit jaded sometimes, and I don't mean to offend anybody, but I saw spiritual leaders and medicine men come out of the woodwork Now, we all know in our tribal communities, historically and traditionally, this is a role that our spiritual leaders were prepared for. They were prepared from the time they were little. So what I saw, and the negative part was, for example, I saw a lot of natives smoking marijuana or weed in their pipes. I saw a lot of misuse of, what is our traditions and our sacred ways of thinking and being. And I saw a lot of people kind of stepping up and say, hey, I have power. And people were so hungry to learn their customs, to learn their language, all because of colonization and, everything that happened to us, the near destruction of our families, our family structures, our belief systems, our ceremonies and everything. I saw so many people just really misusing that power and people so hungry to learn and doubting themselves because they thought, oh, here's someone who knows, and this is what I want to learn. So I don't know very much, so I'm going to listen to this person. But on the same hand, I've seen, and you've all seen the reports across the nation where we have medicine men or spiritual leaders targeting, vulnerable people, whether it's children or youth or women that have been sexually abused in the past or in abusive relationships, where they're struggling and hurting and they're taken advantage of by these people who claim to have a lot of power. So in response to this, and I guess I want to say this to everybody on the call, it's so important to encourage people to follow their own gut. Like if they go to a ceremony and something doesn't feel right, to get away. There are other people. Go to your aunties or a trusted person in your community and talk to them about who is safe, because our spiritual journeys are very personal. And there isn't anyone that knows any more than we do. They might know some rituals or practices that maybe we weren't exposed to, but, we know a lot, and we know the spirituality is about the goodness in all of us. Learning those ceremonies or rituals or whatever, whether it's, putting tobacco out when you pick medicines or whatever it is, whatever your tribe, does. Now I kind of lost my train of thought here, but I guess I'm just trying to say is when you talk with folks that come into your programs, whether it's youth or children, or adults, encourage them to follow their gut. And if something doesn't feel right, go away from that person and, ask someone, because there are healthy people in our communities that do sincerely want to help. That was kind of a long-winded response to your question, Alicia, but it's also an issue that's very, very dear to my heart and a concern that I've seen, over the years. And it also ties in with giving as an advocate, helping to give and help those using our services to make an informed decision. And I think that includes whether to, about your medical records or about who you see in your community. So, yeah, important question. Okay, so moving on. We'll talk about minor consent to medical treatment. There are some exceptions. A minor may obtain a medical exam without contacting a parent to diagnose or treat if they are pregnant or have an STI or STD. And again, this may or may not be true in your community. Find out just to be sure. A minor who is sexually assaulted, receive injuries that risk his or her life does not need parental consent for emergency care. This is another hot topic here, is drug and alcohol facilitated assault. And I say hot topic because regardless of what the policies or practices are of intervening systems, there still are individual practitioners who believe that if someone is drinking or, using drugs of some sort, that somehow they deserve to be raped or assaulted, that they're asking for it in some way, and it just makes me furious. We know that no matter what, no one deserves to be assaulted, regardless. But the way the systems are set up now, responders are, they need to consider the possibility that drugs are used. Typically, they can screen for suspected drug-facilitated sexual assault, get permission to do the testing, collect the examples. But again, as an advocate, think about, what are the unintended consequences, I guess, for the victims that you're trying to help. Sometimes they might collect urine immediately prior to the exam, and they're looking for drugs or alcohol. But, if it's being prosecuted, the prosecutors may, or the defense attorney may use it against the victim, oh, well, she was drunk or she was high on drugs or whatever. So, those are all things to consider, and I, again, encourage you to talk this over very carefully with the victims that you're seeing. What is the responsibility of the SANE nurse, the sexual assault nurse examiner? It can be a nurse, a doctor, an assistant, but their role is to collect the evidence that links the survivor to the suspect. And also a key role is to preserve the dignity of the survivor. They understand what a traumatic event this is, the impact on the survivor, and to the extent possible, they do it as gently and respectfully as possible. But they basically perform the forensic physical exam. They collect the evidence. They may be called in to provide expert testimony, and they will work closely with law enforcement and the prosecutor's office, again, to move a case forward in terms of a sexual assault. Well, geez, I'm getting a little scared here. We're running out of time, but I just want to talk really quickly about domestic assault because we spent a lot of time talking about sexual assault. But, in terms of domestic abuse or domestic violence, what's the legal definition in your tribe? It typically includes some kind of physical harm, which includes all the things I have listed on this slide. It might include making a family or household member afraid of imminent harm by threats or harming someone else that they care about or love. Might be terroristic threats, holding weapons, showing a rifle or a pistol or something, making terroristic threats. They may not do anything physically, but those could be used in your codes. That could be a definition in your codes or in your state guidelines. Criminal sexual conduct committed against a family or household member by another family member. The question I have on the slide here for you to think about is, are there stipulations or provisions for adolescents in your tribe or in the programs or community that you're working in? And this one I think is really important to because we don't always think about this in terms of school protections, but especially with youth or minors, what are your school policies? Now, if you have never checked into that, it's really interesting sometimes what you find out in terms of what the school has in place to protect adolescent victims of domestic violence. And what do they do if an order is in place and it's been violated? What are the sexual harassment policies or their bullying policies? Zero tolerance. Now, this one of the things I've learned about zero tolerance, why this is kind of a nationwide trend, is that schools have zero tolerance for violence. Typically what happens is Native kids and kids of color are the ones that are impacted very negatively by this policy. Number one, they typically don't identify a primary aggressor, and they very seldom respond. Like I've heard so many stories about Native kids with long hair, and they get bullied and teased because they have long hair, and the school does little or nothing to protect that Native child. So, again, I encourage you to look into the policies and, kind of do some investigating and see how they're responding, in your schools. And, what are the cultural considerations, or what are the things happening if it's a tribal school versus a, mainstream, and Native kids are attending a mainstream school. But, notions around hate crimes and homophobia and racism, these are all policies to look at and understand what's in place to protect youth and children. And then what are the mandated reporting laws? Because we know that this is one system many times where a teacher or a counselor in the school might identify something and make a report to law enforcement or child protection. So what are those laws as it relates to the teachers in the schools in your community? And then the final slide I have up here relates to the Indian Child Welfare Act and when equal rights are ignored. And again, I feel like I'm probably repeating a lot of stuff, but or talking about things that you folks already know. But for sure, if you think that a family isn't, if the rights of an Indian child are not taken seriously in the child protection system, or if their rights are ignored, contact an attorney. Indian law experience preferred. You might contact legal services in your community, and for sure, contact the child's tribe. There should be an ICWA rep within each tribe that can help answer any questions or point you in the right direction. The court may order different services or different placements if it's determined that ICWA is not being applied correctly. And of course, that law is a federal law, and there's a whole lot of stipulations that, as an advocate, you should become familiar with when and if possible. There's any number of trainings, maybe you've been to them. But I think it's so important that we protect the rights of our Native children and work to keep them within our communities and within our families. So I'm looking at the time, and I'm realizing that our time is up. I don't see any other questions or comments in the chat box. But I do hope this was helpful in some way. If you have any questions or comments after this, let Alicia know, and I can try to respond after the call if something comes up, or refer you to someone who might be able to help you. But for now, thank you so much for participating in this, and thank you for all you do, every one of you, for our Native kids and youth. And I just so appreciate it. And I know as an aging advocate, they're in good hands with everybody that's doing the work now. So, see miigwech. Bye now.
All right, do we have any last minute questions before we start wrapping up? All right. So, I'd like to thank our presenter, Sandy, and our host, Anna. This will be our last Children and Youth webinar for the time being until the next cycle. So they will be posted up on our YouTube page. That is Redmond Consulting on YouTube. They will also be posted up on our website in the Talking Wind section. And if no one has any questions, then once again,